Attention students, I find it highly imperative that we should make these videos and be in a habit of getting to used to watch these videos, because unfortunately we cannot meet like every day in a week. We only meet once, and the time is always not enough. We talk, and before we finish our talks, the periods are over. So I think it is wise for us to get used to these videos. Please use them effectively, because they'll go a long way to help you with tuition. Um, um, I am doing this one in anticipation of a possible problem type question that will talk about, I think, 3 or 4 areas of law. The first one being law of succession, especially the the reform of Customary Law Succession Act, or Act 11 of 2009, and also the recognition of customary marriages 20 of 1998, including the Administration of Estates Act 66 of 1965. We need to have a look at those 3 legislations, because if you know a bit about those legislation, then you will be able to answer the question thoroughly. I've told you about customary marriages, where you'll find that a customary marriage is not registered, and therefore when a spouse dies, what normally happens is that the death certificate will come out as never married, because the parties to the marriage, the spouses to the marriage, did not register it. So it is wise to register the customary marriage. And the Act says customary marriage should be registered within 3 months after its consummation. And you must know, consummation of customary marriages means that the lobola has been paid and the bride has been delivered to the groom's homestead. Then it's consummated. Otherwise, this notion of that was the lobola fully paid doesn't count when it comes to customary marriages. It doesn't invalidate the customary marriage. So as long as there has been no negotiations, and sometimes even if the bride has not been delivered, if there was negotiations and you can prove that both parties consented to those negotiations, and they are not minors, they are adults. And also we know that sometimes people who are under the age of 18 can get into a customary marriage when their guardians consent, or help them with the consent to marriage. So sometimes you will find a situation where, for instance, the case that I told you in class, where the children of this deceased person are disputing the validity of the marriage between their father and their stepmother, to such an extent that they will go to court and challenge her status of being the executrix of the estate. So what normally happens is that when the marriage is not registered, you as an attorney can go to the master's office with your client, and the master will tell you to bring two representatives from the bride side and two representatives from the groom side to go and validate the marriage. They will make affidavits in front of the master of the High Court, and then if everybody make those minutes, because it will be minuted. Then we have a meeting. We'll have a meeting with the master of the High Court, and that meeting will be minuted. Once the master is satisfied that a customary marriage exists, he will then make an endorsement to say the customary marriage exists. Therefore, the spouse has a right to inherit or to be the executrix if it's a woman, because it happens as well. Even if the spouse is a male, the same thing applies. You will go to the master's office and do the same procedure of having that meeting, which is minuted, and the master will then declare that the marriage exists, and then your client can now be the executrix of that late estate. But one thing that you must always be careful of is that the people who are working at the master's office are even in most cases, they are just students like yourselves who have just graduated from the university because they had clever lecturers. They went and found out from the master's offices to when are they doing their yearly intake, and students will be told to go and go for an interview, or maybe drop their CVs at the master's office. And they normally take, as long as you've got an LLB degree, that's enough. Because if you look at section 2 of the same act, it will tell you that the requirements is actually a diploma. It's a diploma in juris. I don't know what is that, but it's not even a degree or maybe a B juris. It's a diploma in juris. So if you've got an LLB degree, that means you are overqualified for that position. So obviously you're going to be taken. So the master of the High Court is somebody like you, who is not an admitted attorney, who is just an ordinary LLB student who has passed his LLB and graduated. No admission is required. Then you can be employed as the master of the High Court, and your job at the office of the masters will be to open files, to talk to people who have lost their spouses or who have lost their parents or sisters or brothers or children. They will come to the office to open a file. The first thing you will have to ask is that they furnish you with the death certificate. And one thing you must know about the death certificate: the moment a death certificate is issued, all the bank accounts of the deceased are automatically frozen, which means no one will be able to withdraw money from those accounts. Hence, there will be a need for the remaining spouse or relatives to go to the master's office and apply for a letter of authority, depending on the amount of the estate that is in question. If it's if I think if it's more than 300,000 rand, then you will need a letter of executorship. But one thing you must note about the letter of executorship, even the letter of authority, is that most of the time the people who are working at the master's office make a mistake of issuing it under section 13 and 14 of the Administration of Estates Act 66 of 1965. So you need to be careful, because if you just overlook that, you will be in trouble, like myself. Get to the High Court only to find that your opponent is questioning the fact that the section in which your letter of executorship was issued is wrong, because there was no will. Remember, section 14 subsection 1A and B says the letter of executorship can be issued under that section only if there is a will, right? So if there is no will, you will use section 18. You need to be careful of that distinction. Section 18 and section 14 of the Administration of Estates Act of 1965. So you need to be careful that don't just let it go, because it's going to cause problems for you. And also you need to for instance, if the customary marriage was never registered and there's somebody like a parent, like for instance we had a case of WHP, I think the citation there will be Sengati. If you look at Sengati is the lady who was involved in that dispute. That is now the spouse, the wife of WHP. In that case, the father was disputing the authenticity or the the validity of the marriage between his son and Miss Sengati. In that they went to court, and the court said, because there was in the local negotiations that were done, and also there was a ceremony, so a marriage between Miss Sengati and WHP exists. So that's another case that you need to look at to support the argument in the problem type question that I'm going to give. And also okay, students, let's come back to Act 120 of 1998, which is the recognition of Customary Marriage Act. Remember that Act said the customary marriage that existed before the recognition of Customary Marriage Act came into existence, those customary marriage are valid, so they are recognized. So anybody who says, but my customary marriage was consummated before this act came to existence, so you must advise those people that their marriage is valid. The only thing that they need to do is to register it register it in with Home Affairs to say so it has to be registered, right? Another thing is that the regulation was that those marriages should be registered within 12 months after the coming into existence of the recognition of Customary Marriage Act. And also, but it's not, there are no hard and fast rules, even if somebody has not, because it was this act came into existence in 1998. even if people can go now, people who had these marriages before that can go today, still the marriages will be registered. But the law says if you enter into a customary marriage, you have to register it within 3 months. But if you haven't registered within 3 months, it doesn't mean to say you are not, that marriage won't be recognized, but it's what the law says. So you can advise people to go and register within 3 months. And remember, I said we were supposed to get into a project where we will be going around and registering these marriages. Well, we still have time. It will happen. We'll have to go. I am still trying to get relevant stakeholders like the magistrates, the chiefs, and the indunas from various communities to coordinate an outreach program where we will be going to communities to register these marriages. I want it to be done in conjunction with my class, with my students, that we go and register these marriages. And also remember that the customary marriage, just like any other marriage, when it's being dissolved, it will go to the divorce court just like any other marriage, and it will be the same procedure as it's done when you are dissolving the civil marriage. You will use the same procedure. And also you must remember, when a client comes to you in respect of divorce, you need to also try mediation. I'm sure you are familiar with the Mediation in Certain Divorce Matters Act 24 of 1987. You need to consult that act and see what it says. And also when it comes to like we've spoken about the administration of estates, the only route that you should follow is to look at the act. The act will tell you exactly what you need to do when you are helping someone to round up an estate, or helping someone to go about claiming their inheritance from the master of the High Court. So that procedure. And if you are employed there, you will be helping people to open files, and this is how you open a file. When somebody gets into the master's office, they will be bringing their death certificate, their IDs, and the ID of the deceased, and you will have all of that, and you will make copies and then compile a file of the late estate. And there is a prescribed form that must be given to the person who's coming to report the death. Because another thing you must remember is that if somebody dies, you have 14 days to go and report the death at the master's office. That is in terms of section 7 of the same act. You go and report it within 14 days. And when you get there, there will be a form that you need to fill, which is called the inventory. The inventory means everything that is owned by the deceased should be recorded in that register, or in that form that you are going to be given. It will include things like the cars that he owned, the house that he owned, and the cattle, everything that he owned, every property that belongs to the deceased. But you must be careful when it comes to a house, because sometimes you'll find that the house is owned by the husband and wife. So you can't say the house belongs to the deceased, but it has to be added in the inventory. But when you are distributing it, you must remember that the wife has got half half of half of that house belongs to the other spouse. So but you can put it in the inventory, and then the master will decide as how that property will be divided, because sometimes you will have to sell the house so that the children of the deceased can take their share. It can be divided amongst them. They will take their half and they will share it amongst themselves. So it has to come into that inventory. And also there is somebody called the appraiser. And appraiser section, if you look at section 6 of the same act, the Administration of Estates Act, will tell you about the appraiser. Appraiser is somebody who will look at the property, say a car, and then appraise it. That is, now evaluate it. You evaluate it to say this car will cost maybe 100,000 rand. Then if you sell it, it's going to be sold at 100,000 rand. The same thing applies to the house. The appraiser will also evaluate the house and also then sell it so that it can be divided amongst the beneficiaries. The appraiser is somebody who is employed by the master, by the minister, because everybody who works at the master's office is employed by the Minister of Justice and Correctional Services. That you must always remember. And the appraiser will be appointed by the minister as well, and he or she has to be formally sworn in. You take an oath to be an appraiser. So any one of you can be an appraiser, because each time you appraise any property that belongs to the deceased, you get paid. There's a certain tariff that you get out of the work that you've done in appraising any property that is subject to the division of the late estate. So in our problem type, where this means you will be stating the steps that you need to follow when you are advising your client. Let's say your client wants to challenge a case where the father of the deceased refuses to recognize your client as wife or as spouse, so that she cannot inherit. Then you need to advise as to what steps do you take. Obviously, you are going to make an application to the High Court challenging the master of the High Court having given that letter of executive to the father of your client's husband instead of herself. So you will file an application. Remember, when you make an application, it is done by way of notice of motion, and then it's accompanied by an affidavit. It's accompanied by an affidavit, right? And then you will be challenging it, or maybe make an application that interdicts the father from inheriting your client's husband's property or late estate, if you like. So you will state the steps that you need to follow, and also you can raise a point in limine in regards to this wrong section having been used in issuing that letter of execution. So you can think of so many ways of helping your client to challenge anybody who doesn't allow her to inherit because of unregistered customary marriage, or the fact that all the rituals have not been have not been finalized. Because sometimes people will say, "No, but my brother only paid one cow lobola. Then why should we recognize the wife to be the spouse, because she doesn't even have children from my brother, so she has no right to inherit." So you will be helping such people. So yeah, and our problem type question will be around those. So you need to look at like I've said, you look at the recognition of the Customary Marriage Act, you look at Administration of Estates Act, and you look at the, um, the law of succession. That's the reform of customary law, succession, and regulation related to Matters Act 11 of 2009. You need to look at those legislation so that you can be able to advise your client successfully. Let's end there for now.